Bill of Rights is a list of limits on government power and includes the ideas of the Enlightenment and natural rights of man. For example, what the founders saw as the natural right of individuals to speak and worship freely would be protected by the First Amendment's prohibitions on Congress from making laws establishing a religion or abridging the freedom of speech. Another example, the natural right to be free from unreasonable government intrusion in one's home, was safeguarded by the Fourth Amendment's requirements to have a search warrant. Other precursors to the Bill of Rights included English documents like the Magna Carta, the Petition of Right, the English Bill of Rights, and the Massachusetts Body of Liberties. The Bill of Rights, as approved, included the following amendments to the Constitution. The First Amendment read that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and to petition the government for a redress of grievances. The Second Amendment specifies that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The Third Amendment addresses issues dating all the way back to the Quartering Act and states that no soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law. The Fourth Amendment dealt with issues related to the writs of assistance that the British government had used to try and catch smugglers, and stated the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So, for example, you couldn't look for a large, possibly stolen object inside of a small envelope because it simply would not be reasonable to think that you could find that item there. For the Fifth Amendment, this dealt with individuals who were accused of crimes and stated that no person shall be held to answer for a capital or otherwise infamous crime unless on presentment of an indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject to the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. In other words, you can't go to jail and spend time in jail unless you've had your day in court. You have to have an indictment for your crimes. You can't just arbitrarily be charged. You can't be charged twice for the same crime, so no double jeopardy. You can't be forced to testify against yourself. In essence, pleading the Fifth means that you are not going to say anything that could be self-incriminating. The Sixth Amendment continues to deal with those accused of criminal offenses and states that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against them, and to have the compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. In other words, you can't have secret trials. You have to have a jury from the area in which you lived or the crime occurred, a jury of your peers. It can't be a newly created district just for the purpose of this trial, but one that was already recognized. You have the right to confront any witnesses against you. You have the right to have witnesses testify on your behalf. Even if they are somewhat reluctant to do so, they can be compelled to testify as to what they know. And you have the right to have an attorney. In the Seventh Amendment, this deals with civil law, where, for example, one person is suing another, and states that in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law. So in other words, you can have a jury trial in a civil case as well. The Eighth Amendment addresses the issue of excessive bails, saying that it shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. You're not going to see $1 million fine for stealing a sandwich, because that would be considered excessive. Cruel and unusual punishment, again, you're not going to see someone executed for stealing a pair of shoes. That would be cruel and unusual. The Ninth Amendment takes a step further and addresses the concern of the Federalists that you couldn't possibly list all of the rights into one document. So the Ninth Amendment says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. In other words, if they didn't write it down, it's still a protected right. It just falls under this Ninth Amendment. And the 10th Amendment specifies that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. In other words, if it's not in the Constitution as being a power of the national government, and it's not prohibited to the national government, those things are reserved to the states. Now, there were two proposed amendments that were not approved in 1791. One included a provision that would prevent members of Congress from voting themselves a pay raise and having it take effect in the same term. That one ended up being passed in 1992, 203 years after it was originally suggested, as the 27th Amendment now. The other one would have actually affected the number of members in the House and the number of people that members of the House could represent. The amendment is actually technically still outstanding, but would require a minimum of 200 members total. And of course, we meet that no problem because we have 435. But it also specified that there would not be more than one member for every 50,000 persons. Now, if we went to that portion of the amendment, that would now put the size of the House of Representatives, based on the current U.S. population, at more than 6,000 people, and that is simply impractical for working together to pass laws and do things of this nature. So the practicality of this particular amendment ever actually getting passed is pretty much none.